issued from the collector to the project administrator after my appearance of the collector.
True, maybe, but this letter, the copy of the letter was made known to you. You made an inspection when
That is made to PITDA, not to me. That
What?
is made to PAITDA, not to the petitioner.
Or it may not be addressed to you, but at the time of the hearing, it was given to you.
No, not
You
time
had
of hearing.
Then
Not
how you got the copy of the letter?
that
You
is
have an next?
that I got from RTI.
You come to your statement. You have said so. I'm reading from paragraph 5 onwards. You have said on 12/8, the collector recorded your submissions. What
Right.
you have said, that is there.
Right.
Then on 16A, there is a letter which was issued with 2 numbers of enclosures, the Xerox copy, and then PADT searcher for verification is verified by me.
Verified by me at the time of inspection of the file by RTI.
Correct. So you were given an opportunity that these are the documents, you can verify it.
I verified that I found that
On
so
16/8, you were given an opportunity to verify under the RTI. It is
I
surprisingly
verified and I found that that is the false document and forgery document.
true.
They
So
should,
then you must have raised this objection at the time of hearing.
at the time of hearing, I don't know about, because my hearing is at 12/8. It was happened on 16/8 after 4 days.
Sir, the 16/8, you said that the letter has been given. The court has simply said that you give them a reasonable opportunity of hearing. That means that there should be a meaningful opportunity of hearing. You have given him, he appeared. Subsequently, you got some documents. Will you not give him a document? Will you not give them an opportunity to deal with those documents? And these documents put verified on the basis of an RTI reply.
In 24.
And that too in 2024. It was not made known to him. Then where is the reasonable opportunity of hearing which was directed by this court? You know the principles in a disciplinary proceeding also, that is ingrained. If you do not give them all the copies which you really want to rely in course of a proceeding, then it is a violation of the principle of natural justice. This is not expected. The authorities will rely on, and these letters have been relied in the decision.
No. Yes.
Very serious concern.
Fabricated, sir. Because the black and
You
white
will
letters
not,
have been colored.
sir, it appears your signature is there.
My signature, my
which
letter.
tallies with the signature of the others. Let them give the original. Let them come with that, and let us see whether there is any superimposition or not. These are the matter. The contempt court will not go and make a roving inquiry. You go to the other forum.
Liberty can
And
be
another
challenge the
aspect
order.
is there.
Challenge the order.
And another aspect, The order passed in 2021. That was complied. Maybe as per him, it may be a wrong compliance.
Not
But the contempt petition has been filed in 2024 after 3 years. Whether it is maintainable, if your lordship, subject to my lord's.
He has been very interestingly and very intelligently done it. He says that this fraud or something came in my knowledge in 2024 when he received the information under RTI. And 1 year period will start from the day when the
Knowledge.
No.
section 20,
Was the rejection order not communicated to him?
was it communicated to him?
Then you made inquiry after
They
3
made an
years.
inquiry. Where
After
this
3
letter come? I then made inquiry.
When this was communicated to you, 2021,
21?
21.
and then you were waiting for
No,
3
no,
years to
Lordship,
have
Lordship,
2021
honestly, Lordship, I was admitted in hospital surgery in
for
22.
3 years.
No, for 1 year. After second
1
COVID,
year,
1 year,
surgery.
Lordship, I have annexed the documents in Annexer 20 of the documents, Lordship. I hospitalized. Or because I was unable to sleep for up to 6 months after second COVID. Then one surgery has done my sleep apnea. The doctor advised me to take at least 12 months rest. After that, I am unable to see some deposit in my eye on the record, Lordship. Then doctor tell me, don't take any stress. I have not taken any stress. Now I'm eligible to see.
The petition filed by the petitioner came to be disposed of on 14/7/2021 by the division bench. Directing the learned collector, comma, and DM, CEO, comma, SDC, Mayurvansh, to afford reasonable opportunity of hearing to the petitioner and other persons who may be interested in the matter, and to take a decision on the representation made in this regard by the recording a reasoned and speaking order within the period of 1 month. The said order was duly communicated to the authority, and the said representation was disposed of on 23rd August 2021. The tenet of the said order reveals that the authority is informed, proceeding to issued a notice to the petitioner, and after appearance, the submissions and or statements was also recorded on 12/8/2021. First, now, it is not in dispute that the said order dated 23rd August 2021 was duly communicated to the petitioner. However, the petitioner perceived certain observations made in the said impugned order to have an element and or flavor of a fraud which has been committed in relying on certain letters and or documents which, according to the petitioner, is a fabricated and or manufactured one. The petitioner thereafter undergone a surgery and was unable to perform the daily activities, and immediately after recovery from such illness, the application was made under the Right to Information Act relating to the letter dated 17/12/2018, which the petitioner was which the petitioner perceived to be a manufactured one. And after getting the reply, the instant contempt application is taken up, alleging that the authorities have committed a grave error and in not complying the directions in its proper perspective. We had an occasion to go through the decision dated 23rd August 2021, wherefrom we find a reflection of a letter number 519 dated 17/12/2018, where an undertaking was given that after the approval of the script by the purchaser, the petitioner will take minimum 30 days to supply the finished documentary. To stop. To stop. The authorities proceeded. Sorry, our attention is drawn to the documents annexed to the instant contempt application. More particularly, 2 letters bearing the same date and the reference number, which according to the petitioner the letter and being annexion 3 to the contempt application is a genuine one, and not the letter where is that impugned letter? Annexure
Rejection order, Lordship.
and not the letter
Letter, original letter, page
annex-
25.
annexed as annexure 5 there too.
5 is fabricated.
The contempt jurisdiction cannot be expanded to decide the complex questions, more particularly when the genuinity of a document is sought to be raised, and to make a roving inquiry afresh in this regard. The court will, the contempt court shall confine its scrutiny on the allegations made in the contempt petition as to whether the alleged contenders have complied the order so passed, and there has been some negligence lapses which is willful and deliberate, attributable to their conduct. We are not unmindful of the somewhat settled proposition of law that the contempt jurisdiction is not restricted to punish the violator of the law, but shall also see that the order passed by the court is duly implemented. The majesty and the sanctity of the courts has to be preserved, and the court shall not permit any person to violate the said order, undermining the authority of the court with a willful and deliberate act. Once the court finds that the direction passed by the court has been implemented. Whether such decisions infirm or contains the erroneous finding, it invites a fresh cause of action. And the contempt jurisdiction should not be stretched so as to convert it into the court of original jurisdiction. Full stop. While disposing of the writ petition, this court directed the representation to be disposed of within a time frame, ensuring the compliance of natural justice. And we find from the tenet of the order that the petitioner was served with the notice, and in fact, his statement was also recorded. Whether the authorities have committed any error, serious or procedural, it is open to the petitioner to ventilate such grievance before the appropriate forum. Stop. Since the order has already been complied with, though belatedly, we do not find any contemptuous act to have been committed by the alleged contender, and therefore the contempt petition is dropped. Go to the next.
Item number 4.
Yeah, please, Your Lordship. Lordship, there is the review petition filed by the petitioner. A judgment delivered on dated 21/1/2025 under Annexure 1, Your Lordship, in WBC number 30756 of 2024.
Yes.
Lordship, there are such ground, Your Lordship. First of all, this is not case of transfer. This is case of absorption. And thereafter, Your Lordship, the judgment which has been relied upon, that Silpi Bose, is not totally applicable to this matter, Your Lordship.
Can it be gone into a review? Show me one judgment, I will be happy.
Your Lordship,
You are trying to rehear or re-argue the matter. The court has wrongly applied this judgment. The court has wrongly applied this paragraph. These are all a re-argument which has been done, which is not a subject matter of a review.
on the very threshold, this matter has been dismissed by the division.
Whatever that can be, is there any law says that you cannot dismiss any matter
No, Your
on the
Lordship.
threshold?
On the ground that is erroneous, Your Lordship. Therefore,
Erroneous decision is something else than a decision containing the error apparent on the face of the record. Erroneous decision, you go before the higher up. But
Your Lordship, why it needs
my own
Your
judgments are there, distinction based upon a Supreme Court judgment way back in Tungabhadra.
You have to bring it within the parameters
Have
of
you read
review.
the Tungabhadra's judgment of the Supreme Court?
No, Lordship.
Read that, the scope of the review. Rupa Ashok Hura, you read. Can't be. Review cannot be stressed. And they have recorded in paragraph 10 the absorption and all, everything has been recorded.
Lordship, but that is it's a absorption. This is not a transfer, Your Lordship.
So whatever,
And the option which has been provided to the petitioner, Your Lordship, before the corporate,
this
the
is what
posting
we
has
have
been
recorded.
done, Your Lordship.
In page 12, we have recorded that the application filed by the petitioner renews the prayer was made to cause the order of absorption of the petitioner is RMS and division, and for direction to absorb him in the post of post assistant. And the court has thereafter decided.
But
So it's an erroneous decision.
relied upon that decision of transfer, Your Lordship. This is not a case of transfer, Your Lordship. It's a case of absorption, Your Lordship. As because
It was two twin prayer. One is absorption. You are challenging the absorption to the post of RMS division,
yes, Your Lordship.
and you wanted an absorption in a postal assistant
In circle office, Your Lordship.
or in circle office. The
Sir.
court, and you have been directed to be posted in that RMS and division.
Yes, your lordship.
Absorption was made.
Observation made wrongly, your lordship.
What?
That
Sorry?
is my prayer, your lordship.
Do one thing, who's for? We are reviewing it and then dismissing, and the order of absorption goes. And let him remain. There will not be any absorption.
Lordship,
He remain a contractual employee.
no, your lordship.
No, after order of absorption goes. What
This
will happen? What will be the status?
Your lordship, may I
I
submit
am
one
asking
thing?
you, sir. What will be your status after absorption? Order goes.
Your lordship, this absorption has made due to closure of that postal printing press, your lordship. Due to closure of,
Exactly, that is why it is asked, once that order goes, where will you be?
Try to understand, the court has been very. And they have shown, I think, some benevolent.
काय हरण करছে boy गोटे गोटे पे
reason they have assigned that due to lack of administrative knowledge,
No,
your lordship.
nothing. Did you write a? No. Let us just review again.
Not again.
The very extensive judgment.
The actual error apparent on the face of it.
Oh,
That will,
you were trying a parity with 63 candidates.
not even that. That is one limb of the submission, but subsequent, but kindly see para 30, that will, I think that will settle our case. After careful, may I please,
Yes.
35, page 35. After careful hearing, in paragraph 13, after carefully hearing the loan counsel and going through the records and the decision of Supreme Court, you are not convinced with the submission advanced on behalf of the appellants, who are the appellants, that the state was under obligation to fill up all the vacancies existing prior to 31.
It says that you do not belong to the ST and SC category.
Yes, but we SCs were available, that's the present appellants.
Sir, the question is that the positive finding is that you do not belong to ST and SC.
No, no SC/ST candidates are available. But we SC/ST are available, that is they are the appellants.
Sir, question is, you are referring paragraph 13.
My lord,
Please come to the last two lines
yes.
at the bottom.
Hmm.
What it says.
Well, the appellants do not belong to SC and ST, but
That is what I'm saying, that
Yes.
you do not belong to ST/ST category, ST/SC category. Now at page 41, paragraph 17, which is the ultimate decision. You wanted a parity with 63 other candidates. The court has said that you can't because they belong to ST category.
even my lord, for
So you can't. They are a distinct class by itself.
my humble submission for my lord, that the present appellants are SC categories, they are
Where do you say
Because
the
that is
court the positive finding of the court is that you do not belong.
but the fact remains that the list which is under challenge, we belong to that requisition is with the government, the panel is with the government, and the government advocate says they are not the SC/ST.
Sir, please, what are the records or what are the documents on the record which would say that you belong to SC/ST category and this finding is wrong?
The panel,
Show us from the writ petition, the document, any one document
my
which
lord,
would throw light on that.
my lord, kindly, both may I submit my lord one aspect? The present appellants,
Sir, I am asking you a very specific question.
yes,
The court has arrived at the positive finding that you do not belong to SC/ST category.
that,
That according to you is wrong. Show us that what document was there in the writ petition which would prove that you belong to SC/ST category. Simple question I am asking.
permitted. This finding of the honorable court was on the basis of submission of a government report. Now, that is correct, my lord. So
No,
that,
That is why you show us that
kindly
that
see-
submission was wrong from some document you show us,
that
which
gently-
was there on record.
If I permitted, then there is a panel, my lord, kindly bear also on me. The
Sir,
panel
was that panel?
includes us.
Please show us that this panel was included in the writ petition. There you have been shown in an SC/ST category. Everything you are considered, show us the document I want.
But is it not,
When you know the scope of review,
my lord, I am conscious of the review patent error. Why I submit patent error?
patent error, what?
What is factual error?
No,
One SC/ST
no, sir,
available.
no, sir. I think you have, this is a half-baked argument. Not a patent error.
SC/ST.
The error which is patent on the record. What is the meaning of the word on the record? Under order 47, rule 1 of the Code of Suppositor.
Any sufficient reason, my lord?
What?
Sufficient reason means we are available. SC
What sufficient reasons?
SC candidates are available in the
Sir,
panel.
I am conscious. Are you aware of those line of judgment where
Yes,
or
I'm-
other
I'm
substantial
obliged,
cause, sufficient reason must be linked with the others?
Discovery of facts. We,
Discovery of new and important materials which were not known to you despite due diligence.
yes.
Now you show me that where you have found due diligence. Show us. Show us from the facts. Sir, what you are referring?
That is that post remand vacant for SC/ST, for SC.
Sir,
But I
here
understand.
having
I
one
understand.
document in the pocket is not sufficient. When the statute says due diligence, then you will have to discharge the due diligence concept.
Then my lord, read appeal that must be there. I will take one data because schedule, why I say scheduled caste candidates are available in the panel.
I
And
do
state says,
Sir,
state says that there is no state scheduled caste tribe for candidates available. And we are the candidates.
I do not want to go into this aspect.
Now, whether such a pleading is there,
Well,
I'll minute scrutiny will be there. One minute scrutiny because it will go against minimum 17 and how much? 19 candidates. Panel is there,
Sir,
government knows.
come with the judgment. I am on that.
Judgment is.
Show us that the court will reopen the entire issue.
Not reopen.
will
No, not-
hear the
They're
matter
not,
again,
they're not going to
will
reopen.
rewrite the
No, no,
judgment
no.
again.
I am obliged for the knowledge. But question is that we have to show in the writ appeal, what is that contention is there?
I am asking you, sir, when it is-
Writ appeal.
do you think that the procedure which is available in the Indian judicial parlance, that the judge while writing a judgment shall not use any word which is not there in the plea?
Yes, yes.
That is what you say.
What I humbly
Or
submit.
the judgment is independent, it is a purely prerogative of the judge how to write a judgment, how to use the word.
My lord, what I humbly submit, kindly allow us only that whether there is a specific pleading, what I, my lord has already said, is there in the writ or writ appeal. That is the only point I have, otherwise my lord has already enlarged the scope and has given us the pointed. When
Sir,
no,
you did know. You are arguing engaged for a review.
if you only,
Advocate and record who
For-
was there.
he is not available.
Huh?
Advocate
Who
record,
has filed this
review application.
review?
Myself has appeared, but Mr. Oza has appeared.
He was not in the appeal.
No, both the apply.
You were not there.
No.
Please read the another Supreme Court judgment, AIR 1997 Supreme Court, page 1005. It's a technical one, whether you can appear or he can appear.
No,
Both-
I'm on notice, I'm appearing for the
No,
opposite
no,
party.
whether
From
you can-
opposite party.
He is opposite. You can
What
appear. Please read the judgment. Supreme Court in a very strong words have deprecated this kind of,
Yes, yes. I'll go through it, but he.
go through it, don't argue.
No, my lord asked about his locus standi.
No, I
He
just
was
thought
along with us.
he's leaving, he's appearing with you. I just thought that he's assisting you.
No, no. He's also a co-applic, along with
Whatever,
others.
I am talking about you. 97 Supreme Court is here. Give it to him. Give it to him. Read 97 Supreme Court. A small judgment, particularly paragraph 1 or 2, sufficient for you.
But he was active.
Sufficient for you.
This candidate, this present
I am
appellants
talking
were along
about
with
you.
him.
Please,
Can it be only one day? 7 days
you just
after?
go through it.
I'll go through it.
Just
I'll
giving
go through
you,
it.
giving you an opportunity to go through it.
But the question is that
Here-
here, my lord, what are
Question is that judgment.
Supreme Court, sorry, scheduled caste candidates are available.
Question is
But
that
because
judgment.
there is no scheduled caste persons in the panel.
Sir,
in
the
case.
Supreme Court in that judgment says that the court will not permit any litigant to engage the lawyer who did not argue the main matter, but to argue a review and then reopen everything. The Supreme Court has deprecated cost in 1997 was 20,000. So now we are in 2025. I think 28 years have, or 2026, 28 years have
Advocate
gone.
from Delhi. So he
Please,
was
give
honorable.
him.
That is the
Give
reason I
him
appear.
1005, I believe so.
Here the case is different, my lord. The constitutional advocate is from Delhi.
So
He
without,
turned it-
without reading the judgment.
No, I
You are a
don't-
very seasoned
why should I
advocate.
disbelieve, my lord? My lord says, I will go by that. I will not
Then
even
you
go.
can't appeal.
I will go.
After 28 years, what should be the cost?
But Rajab, mostly different occasions, different realities. The person
What
concerned
is the
advocate
different
was not
occasion
well.
reality?
Come with him.
No. Here the question is where you,
That honestly say, I didn't
so
argue.
that is the point in that case.
What
So-
my lord, I was arguing.
No, we are not saying that you are arguing it without taking consent or anything. You can, but Supreme Court has said if you are not there,
Not consent.
how do you know? How do you
He's
know?
there. He's there in the fan. He's
How do you
now.
know what was argued?
Oh, then we will take up next matter on that. Yes, we have another bench yet. This may be on a 10 days, after 10 days. 13th of February is okay. So let's do it. Go through that judgment.
Yes, yes.
One more.
On that.
Yes.
Yes.
So admission item number 1.
My lord, this is non-compliance of the orders of this.
Which is the order? Can you show us the order?
This order was passed on 6th
Compensation with interest.
July 20th. Page number 21, my lord. This was
2
communicated.
months.
Oh.
Yes, that was 2022. When you have filed, sir.
By order, this
When you have filed the contempt, sir,
24 minute, 1/8/2024.
beyond 1 year,
Not maintaining.
not maintainable, section 20 comes into play.
This was communicated, my lord.
Sir, I am asking you, this has been done.
The second one is maintainable. You had earlier filed a writ contempt petition. The second contempt you have filed, but in the first case, no earlier contempt was filed. It is beyond period of limitation, so it cannot be entertained.
This was
Pallab Seth's judgment of the Supreme Court, sir. It says
And,
that section 20 has to be activated.
and
you
item number
seen-
1 and 2 are similar.
Have you got the Pallab judgment,
Yes.
Seth judgment?
Yes.
I think Justice Ruma Pal was one of the member of the bench.
Subsequent judgment also.
Subsequent.
Rupati Rao, 2024.
That is the settled law. sir.
First time the Pallab judgment, Seth judgment is the first judgment
That has been.
on
Para-
limitation.
That's it, paragraph 53. Paragraph 53 and 54.
No, this is the 24 judgment. Where is the earlier judgment?
Millet Pallab set is taken note of it. That paragraph 54. 53 and-
Paragraph.
53 and 54 millet.
So what to do? Yes, Pallab Seth has been taken care of.
53 millet.
It should be brought within a year and not beyond.
Sir, what to do? Can't be.
Please consider this.
We can't go beyond the law. Can we go?
We do not take up any accordance with what is permissible.
Have you taken a decision?
Millet,
Compensation and all?
millet, they're about to take a decision because,
In the connected matter, also the matter issue is same.
yes,
He has taken appropriate step in the connected matter.
yes.
But in the past case, he cannot file.
It has to go, sir. A preliminary objection is raised by the counsel appearing for the LS contender that the instant contempt application is hopelessly barred by limitation provided under section 20 of the Contempt of Courts Act. The contempt application arises on a allegation that the alleged contenders have willfully and deliberately violated the order / direction pass on 16/12/2023 in WPC number 11440 of 2020 in not paying the compensation along with the interest in the event of any construction is made on the land within 2 months from the date of the production or the communication of this order. It is not in dispute that the said order was duly communicated to the alleged contenders. But the instant contempt application is taken out alleging that despite having made known to the said order, the compliance has not been secured. Section 20 of the Contempt of Courts Act provides a period of limitation for initiation of a contempt proceedings within a period of 1 year from the date when the alleged violation Where is the contempt of court act? Here. That was the whether it is.
That provision have not been interpreted. It will- Daniel, provided from the date of the alleged contempt.
Provides a period of limitation. What I've said? From the date, the one from the date on which the contempt is alleged to have been committed. Admittedly, the instant contempt application is filed beyond 1 year from the date of the alleged contempt to have been committed. The court put a timeline within which the directions have to be complied with. And the moment such time stipulated in the said order expires, it gives rise to a contemptuous act. And the period of limitation provided under section 20 of the said act start ticking. Full stop. It is mandatory on the part of the person to approach the court, alleging that its order has been duly violated within the period of limitation provided under section 20 of the said act. Even if the High Court is conferred with the power to punish for his own contempt under Article 215 of the Constitution of India, yet the moment the Contempt of Courts Act have been promulgated, incorporating a provision relating to a period of limitation within which the litigant must approach, the same has been given a primacy which can further be codified from a 3-bench decision of the apex court in case of Pallav Seth. In the said report, observe within courts, it's true that the High Court can invoke powers and jurisdiction vested in it under Article 215 of the Constitution of India, but such a jurisdiction has to be exercised in accordance with the procedure prescribed by law. Unquote. The 3-bench ultimately held that once the procedure of law or a validly enacted law is envisaged in a act, the proceeding for contempt being a quasi-criminal in nature, the punishment can be ordered by the court, is strictly adhering to the stringent provisions, therefore. Full stop. The decision of the three bench rendered in Pallav Singh is reiterated and restated in a subsequent decision of the Supreme Court in case of S. Tirupati Rao versus M. Lingamaya and others, reported in 2024 SCC Online S1764 in the
$53, 50%.
53 in the following, paragraph 53 and 54. Undisputedly, the instant contempt application is taken out beyond the period of limitation provided under section 20 of the said act. And therefore, we find substance in the preliminary objection raised by the counsel appearing for the arrest contempt. The contempt petition is thus dismissed, being barred by repetition. No order as to cause.
Item number 2.
This is
Same, sir.
Find a contempt, please within time.
In this matter, Millard, government has taken a decision, Millard, to pay fees 15,47,000 to the petitioner. We'll file an affidavit.
Either affidavit, pay,
So where is the distance, sir?
Yes, Millard, only
pay.
we have got an instruction.
We have already got.
Yes.
We are keeping this matter after fortnight. In the meantime,
Yes.
pay.
Yes.
It is submitted by the counsel appearing for the arrest contempt that the government has already taken a conscious decision in disbursing the amount so determined to the petitioner and seeks an accommodation in this regard. In view of the above, let this matter be listed after fortnight. When the counsel appearing for the arrest contempt shall apprise the court as the disbursement of said amount to the petitioner. Next.
Item number 3.
Item number 3, Your Lordship,
What is the direction pass?
Lordship at page 8, the relevant order, Your Lordship. The direction is at para 2 of the order, page number 10.
Have you filed a review?
The review, we are in the process of filing the review.
What is the process?
But
The order was passed way back more than 1 year. It's still in the process of review.
I don't happy, sir.
Here
But
also,
did not enter.
here also my learned friend has filed an application for condonation of delay. my lord.
That is not
Is that
maintainable
clear?
at all.
Once
I will not praise that particular IA because I know that condonation delay will not be maintainable for a contempt petition.
Why you know?
Lordship, that will not be maintainable.
Not.
Will not.
Don't you have any judgment in your kitty?
And probably I found otherwise.
Yes. Comply.
So review, we will.
You have to comply, Mr. Das. You do not find a place of the liberty granted by the Appeals Court.
For more than 1.5 years. July, now we are in the back end of the January 2026.
But there is already a proposal. We'll
What
file-
proposal?
We have received the proposal.
No, sir.
We'll file the review. in the
No,
meantime.
sir.
So in the matter listed, you are taking that plea.
No, this cannot be done. Cannot be done. You have to comply or we have to issue some directions.
May grant me week's time.
No to weeks.
Week's time may be granted so that.
For complaints, not to file a review. On merit also, Apex Court did not interfere, only granted you leave to file a
Liberty
review.
to file the,
You have not filed it.
that. voting
Very
fair.
interesting ground was taken that the writ petition was disposed of on the day when it was
Listed.
listed. Why not? The Supreme Court has said nothing doing. If there is no merit, the court can dismiss it unnecessarily. Why the court will keep it pending? The direction was in this matter, Anand Das. The direction that it will be applicable in this case. Yes. You are in contempt. We cannot be a mute spectator. As per your leisure time, you will take a decision whether to come after 5 years.
So
But
that's
contempt
it.
is pending.
Even if you file a review, it will be bad by time also, it will be dismissed ultimately. Because it's 1.5 hour in, 1.5 hour delay. There is no meaning in filing a review now also.
Let's see, understand my, but I'll.
No, file a complaint, sir. File a complaint.
I understand. No difficulty, we are recording.
I'm sorry.
We are recording.
Your Lordship,
Don't worry.
grant me 2 weeks time.
We are
So that I
granting
in the
2 weeks
meantime-
time, but we are recording something.
I'll take.
We should record so that at least, yes. The writ petition filed by the petitioner was disposed of on 18/1/2023. In the light of the order passed in WPC number 15433 of 2012, written by Anand Das versus State of Odisha. Stop. Consequently, the order of rejection dated 20th December 2022 was quashed. Stop. The said order was assailed before the apex court in a special writ petition within the civil diary number 25636 of 2024, which was listed on 11/7/2024. Stop. The apex court did not find any merit and
The apex court has observed that.
they did not find any.
Instead of entering into the SLP on merit.
Sorry, they did not find any grounds warranting the interference with the said order. But however, a liberty was given to the petitioner to approach this court by filing a review application. Despite such liberty having granted as far back as on 11/7/2024, till date, no such review application is filed. The contempt application has intervened in the meantime. And sensing that the court will proceed to adjudicate the instant application, a submission is advanced that the state is contemplating to file a review. More than 1.5 years has elapsed in the meantime. The court cannot be a mute spectator, nor should proceed on the ipse dixit of the submissions advanced by the state. The majesty and the sanctity of the court is paramount, and it is a solemn duty of the court to preserve the same. However, a prayer is made by the counsel appearing for the arrest contempt. To take a necessary instructions. let this matter be listed after fortnight. With a profound belief that the state would take a sensible decision in this regard.
Item 4.
Gratefully.
Item 4, may
Of which orders are
the order dated 13/12/2020.
Mr. Mishra, on the last occasion, my lord has raised a point, whether the review is reasonable because of order 47 rule 1. Because basically a subsequent order, you are filing the review,
Yes.
whether it is maintainable.
No,
And there is a direct decision of the apex court also,
No, but-
which goes against you.
that was the query of your lordships.
Yes,
So
sir.
may I humbly submit, my lord, since I had filed a writ petition and subsequently filed an application for recalling of that order. And after the order was passed by this honorable court in the divisional bench, I have filed this present review petition on annexure 15, my lord. And with that, as it may I permitted to agitate the grievance before the honorable.
Go there. Yeah, we are not making any.
No, why I am submitting? Because initially I filed a writ petition. It was not written as, so that's why I am seeking liberty, my lord.
What liberty? It's
Liberty.
open. We are simply withdrawing it with an observation that withdrawal will not stand in the
My
way.
lord, my lord.
So the counsel for the petitioner submits that his client does not intend to pursue with the instant review application, as he has already ventilated the grievance in the other forum.
No. I have
He
to
will-
ventilate.
That as he intend to ventilate the grievance before the appropriate forum. To stop. In view of the above, the writ petition is allowed to be withdrawn. Sorry, review petition is allowed to be withdrawn. Stop. However, the withdrawal of the writ petition, the review petition shall not stand in the way of the petitioner in ventilating the grievance before the appropriate forum.
Item 5.
Item 5, they filed a
My
IA
lord.
89 of 2005 just now. So
What IA?
My lord, because during pendency of the contempt petition, they have rejected our prayer for compassionate, my lord, for compassionate appointment.
For IA,
Order-
for this, the IA to what?
My lord, only to bring it to your lordship's notice, because this is also contemptuous of the
Why?
alleged
Where
contemnor.
is the order that they cannot reject the application?
My
Where is the
lord, may
order?
kindly see, this honorable court directed that my case is covered to the decision of honorable apex court in case of Malayanandi Sethi versus state of Odisha, and
Correct.
consider the case of the petitioner according to Malayananda Sethi case.
Correct.
But they have not misinterpreted the order passed by this honorable court, and they have given another order of honorable apex court and rejected my prayer.
So if this.
That I-
am just asking.
My lord.
If the Malayananda Sethi's judgment of the apex court
My lord,
is rendered by a higher quorum of the Supreme Court to be a bad law or not a good law, then are they bound to?
no,
follow
my lord, that
law?
has not been decided.
I do not know under the.
Mr. Tripathi, now the government has come up with a new notification. You challenge that on press order, they're taking recourse to that new notification will get the benefit. Why are pressing this contempt? Because my lord, since 2001. You have to challenge that rejection. Challenge that rejection by filing a writ petition, press writ petition. It can be decided. Now government has framed a new set of rules. My lord, again I have to go to tribunal. Go there. Then, my lord,
What? Is a tribunal under Article 323A?
my lord.
323A.
Move there.
Go there.
My lord, give me liberty.
Have they applied the judgment of the Supreme Court in Himaya?
My lord, my kind,
What?
see,
What judgment you applied?
my lord, that is state of West Bengal versus Debabrata Tiwari.
Of which date?
civil appeal number 8842
Yes.
8842 855.
I'm afraid, which,
That is
That judgment?
3/3/2023.
3/3/23.
Better not to place the judgment. Maybe there is a possibility.
Have you got that order? No. Then come prepared with that order on the next date.
My lord.
Judgment.
My lord, I have not seen the.
Please look at.
So, yes, I will go through it. Perhaps, my lord.
May not be.
My lord.
May not be. Keeping it after 2 weeks.
Yes, my lord.
You come prepared with that judgment.
Yes, yes.
Item number 6.
That the last order dated 15/9/2025. Your lordship have granted them time on their prayer for compliance.
12/9.
12/9.
12/9/2020.
Yes, sir. Sir. Where is Mr. Das? You appeared.
No, my lord, today morning I have taken the instruction.
Oh,
He's providing the, Mr. He's providing the
letter,
instruction.
authentic letter.
Let them survey copy. I will take
Giving
instruction.
you letter of appointment is
It has not been served on me.
On
because I-
29/1.
7 days time is given to you to join.
It is compliant, Mr.
Yes, ma'am. Yes, madam. In that event, your lord.
It has already go and join.
Yes. Yeah, lord. Well, because today morning at 10,
I'll try that.
On that basis. Yes. Disposal. We are disposing of the contempt. We are not going ahead. You have been blessed with the service. Don't appointment.
Be happy with that.
Okay.
Item number 1.
May I please, Your Worship? The second contempt application,
Oh, second,
second,
how it is maintainable?
my lord, this honorable court directed earlier on, Lordship, may I kindly see,
How the second content application lies?
Lord, previously that liberty.
What? Can the court touch the original order
Lordship, may I
in a
kindly-
contempt jurisdiction? Tell me under the Contempt of Courts Act, whether it provides for a second contempt.
Lord, that the order of the Lordship, this honorable court's order has not been complied with till today, but that order has passed on 29/1/2023.
9/1/2023, page 13, Your Lordship.
Yes.
And this contempt petition is filed, my lord, on 26/5/2025.
Thereafter, may,
So,
thereafter, I filed another application, contempt application I filed on 18/1/2024.
yes.
The order is at page 19, Your Lordship.
5/2/2024.
19, page 19.
When the first contempt was filed?
The first contempt was filed, my lord, that was
Within-
disposed
within-
upon
Within time, Your Lordship.
page
Within time, Your
19.
Lordship. That 18/1/2024
Yes.
and disposed of on 5.
That was disposed of on 5/2/2024.
20.
3 months time was given. So. Or will you not?
Let the, I have to file an affidavit, my lord, in this matter. For the first time it is coming, my lord.
First time, what is?
Yes.
File your affidavit. Plea of limitation cannot arise because there is a further direction on 5/2.
Yes.
So if that order is also not complied with, then the attempt is within the jurisdiction, within the time. Yes, the counsel for the LS contemner appears and submits that they may be given an opportunity to explain the allegations made in the instant contempt application. The LS contemners are directed, 1 or 2.
Only one.
LS contemner is directed to file the counter affidavit to the contempt application within 2 weeks from book. Rejoinder, if any, shall be filed within a week thereof. The contempt application is made returnable after 3 weeks, give a time. Right.
Item number 2.
Item number 2, may I plead, my lord? Challenging the illegal demand raised in favor of the petitioner
Illegal demand.
for conversion fees. Petitioner has approached this honorable court, and this honorable court under Annexure 1
13, my lord, page 13.
page 14 is the operating portion of the order, my lord.
Page 15.
Yes, my lord, page 15. The impugned demand is
Additional land officer will forthwith issue demand for conversion fees on the basis of that order of 22nd February.
yes, my lord.
Within 3 weeks.
Demand has to be raised within 3 weeks, and the complaints has to be made within
And
30 days.
complaints within 30 days.
That order reviewed under Annexure 6, my lord, and that's were dismissed by the honorable court. Again, approaching
No,
On
no,
20
have they done it?
no, my lord, they have not
No,
done.
demand for conversion? Why-
Even after dismissal of the honorable
why
Supreme
it
Court.
is not done? Sir?
My lord, I have received instruction in this matter, my lord, today, and it is already done.
Done.
Yes. And the conversion fee he has to pay, that is amounting to rupees 16,42,500 only.
I pray for a copy of that letter.
It is submitted by the council appearing for the res contemptor. The additional land officer has already ascertained the quantum of the conversion fees and have quantified the same. But the same could not be communicated, but the counsel for the petitioners showed his inability in this regard, as according to him, the same has not been communicated. Stop. The counsel for the arrest container is directed to communicate the order of demanding the conversion fees upon the learned advocate appearing for the petitioner in course of this day. Yes. Let the contempt application be listed after, that's 3 weeks when we are stated.
Obligation.
Item number
You
3.
comply in the meantime 3 and then.
Obligation. Item 3.
Who is appearing? There was a direction. Reinstatement of the petitioner to other contractors. Have you done that?
Millet, state is not the party here, Millet.
Then who is the party?
Millet, manager HR IFCO.
Who is the contemner?
Notice is to go, Millet. IFCO Paradeep.
Oh, then why you are appearing?
No, Millet, we are not appealing.
Notice, 3 weeks. Records within 1 week from date.
Item 4, same, Millet. Same party.
Yes, same party.
Same party.
Yes. Notice.
Item number 5.
Millet, here, let's kindly see flag A, Millet. They have filed an IA for withdrawal of the review application.
IA for?
Withdrawal of the
Withdrawal of
review
the-
application.
You want to?
No, Millet.
Oh, you want to withdraw?
Yes, ma'am.
Yes. The counsel for the petitioner submits that his client does not intend to proceed with the instant review application. And in order to corroborate the aforesaid fact, an interlocutory application being IA number 358 of 2025 is filed in this court. So after perusal of the averments made therein, and upon submission, having advanced in this regard by the counsel for the petitioner, we allow the said application. Liberty to redress the grievance before the appropriate forum. The review petition, as a consequent, consequently, the review application is also dismissed as withdrawn with such liberty. Yes.
For admission, item number 1.
My lord, I am for the petitioner here, my lord. The
My brother's order is not complied with.
my lord, my lord has interfered, my lord. For that, the people are got some light after this order, after the order in the
Which is
review.
Which is the order?
My lord, the order is at
Page 16.
21 September.
Page
Page 16, it starts, my lord.
and
And the relevant portion is
relevant portion is.
page 20, my lords, para 9.
Para 9 is the order.
What you have done, you have not completed by.
My lords,
31st December.
may kindly have a glance at my lord's order passed on 20th of June. My lord, in this contempt case, 20th of June 2025. There, my lords, on 20th of June, my lords, considering the enormity, my lords, and the volume of petitions, my lord, we have stated before, my lords, that we have received 1,435 applications. Out of
Yes,
which 90
anyhow,
cases
this
have-
was a Rath Yatra exercise
Yes,
that
so
was
my
done.
lords had allowed.
But now it has.
Yes, my lords. My lords had permitted 3 months' time. Now 6 months has elapsed. But, my lords, substantial progress, my lords, has been made. In fact, all these applications have been inquired into, my lords, and the reports have been submitted. Thereafter, my lord, the forest officer, my lord, the opportunity of hearing was given to all the applicants, my lord. All of them were heard, my lords. Now, my lords, after that hearing has been concluded, and now, my lords, as per the Wildlife Reservation Act, my lords, 3 options are there under section 24 under the Wildlife Protection Act. My lords,
Whatever,
My
the court has not opined anything.
yes, my lords.
The court has said when has fixed a deadline within which
My
everything
lords.
is to be done. Will you not do
Yes, my
that?
lords. My lords.
We have been very liberal
My lords have been
in,
very
in
liberal.
there, but that cannot be taken as a premium
My lords.
to continue with this exercise for all time to
No,
come.
my lords. My lords, we are
The
the
order
last
was
leg.
passed as far back
Yes,
as on
my lords.
21st of September.
My lords.
Now 2023.
My lords.
Now we have more than 2 years have elapsed.
My lords, yes, my lords.
We can't sit eternally for all
No, my
time to
lords.
come.
No, my
That
lords. But-
there's once some concession was given to you,
My lords.
you take it as
No, my
a
lords. My lords, there is substantial progress, my lords.
bonanza for all time to
No, my
come.
lords. My lords, my submission. my
Sorry,
lords,
we
there is
can't
substantial
accept
progress.
it.
Now, my lord, we are the last.
Sorry,
leg.
we can't do it.
My lords, my
We'll have to, otherwise
No, my
we are
lords.
issuing a notice. We are issuing a notice. We are issuing a rule.
My
Then
lords,
why
kindly-
I should not do
My lords,
that?
may kindly have the instruction, my lords. I've given,
Sorry,
my
we
lords.
can't. This is
My
not a
lords,
way. This is
my
not a writ petition, sir.
My
You are
lords.
in a contempt.
Yes, my lords.
Your every action is being tested on the anvil of that particular directions.
There has been delay, my lords, I bow down. But,
So,
my lords, considering the.
Are you aware of the Supreme Court judgment
My lords,
of 2012 of a 3-judge bench which says that a delay, dormant and lethargic attitude in applying the order is a contemptuous act?
Yes, my lords, I bow down.
What more?
I admit, my lord, there is
Sorry,
delay.
we can't.
I admit, my lord.
Admit, then
But my lords,
let
my
you
lords, may
face,
kindly have, my lords.
let you face the
My
consequences.
lords, the enormity of the exercise. my lords,
June,
that is-
we gave you some, we were liberal because of the Rath Yatra being there.
But, my lords, after
But that does
my lords,
not mean-
We have made, my lord, there is.
What?
We have
Then
left-
July, August, September, October, November, December. Now January is
But,
gone.
my lord, there is a.
More than
process
7
that-
months have gone.
My lord, there is a process that we have to follow.
Sorry.
My lord, we have left no stone unturned. My lord.
No, sir. It does
My
not
lords,
appear
see,
to us. Your
1500
conduct does not instill a confidence in us that you have been doing it with all commitments.
Yes,
Sorry.
my lords. My
You
lords,
just
1500%
wanted to do dilly-dally things
my
and
lords,
all
my lords,
everything.
The
Sorry.
claims filed by 1400 persons, my lord, they were verified physically.
Every time some instruction.
My lords, may
Convince the judge, you could have convinced the bench on that day that 3 months time is too short for this.
Yes.
The bench should have given you more time.
Yes, my lord, that.
You did not.
We asked for 3 months and my lord.
Sorry. Then
But my lord,
No,
kindly
sir.
understand. My lord, after that.
how many
1500
3 months
persons-
have already elapsed?
My lord, absolutely correct, my lord. I
No,
totally
we
bow
can't.
down, my lord.
And
My
this
lord,
kind of exercise in a contempt is not
my
acceptable.
lord, after that, 1500 persons were heard in person, my lord. Opportunity.
Whatever, sir,
So
whatever
now we are the last
you
leg.
have all the infrastructures, you have all the manpowers,
But
you have
my lord,
everything with
we have to
you.
follow the process, my lord.
Sorry,
We appreciate.
Process
And my lord,
is not cumbersome or so complicated.
my lord, it also.
What are you talking
My
about?
lord, the volume of petitions received, my lord.
Nothing.
Volume
It's a
of
volume of
claims
petitions.
received.
My lords, that, my lord, that is the
That
only
cannot be done.
factor. And now, my lords, we are the last, like, my lords, may see
Just
the last paragraph.
There was no inquiry till the my lords passed the order.
Yes.
Then after passing the order,
Is it true what they are saying even as on date that all these 1400 applications have been heard?
my lord, that information I don't have because they are
Last time
they
you
are
said that only 90 applications were heard.
90.
Now-
That information I have that 90. Thereafter, what has
Because again,
happened?
they will come that many of the applications have not been heard.
Not been
Yes,
heard,
or no?
my lord.
My lord,
That is
all
fine.
of them have been heard. Thereafter heard in person, my lord, they were called and heard in person. Now, my lord, may say, I have given the letter issued to the, my lord, under the Wildlife Protection Act, to the forest warden. There is a statutory provision, my lords, we see. My lords, section 24 of the Wildlife Protection Act, there is a statutory provision, my lords. Either the government can acquire the property.
No, that plea you could have taken, as my lord is saying, at the very initiation of
My
the
lord,
contempt.
my lord,
State
the
has not
entire
done it.
process should have been completed within 2 years from 1987.
My lord,
And in the year 2023, my lords have passed the order. Still 2 years already elapsed.
in 23, my lord, we were given time up till December 2024. Yes, my lord.
And
I
people
admit
are
that-
not able to use their land, my lord.
No,
I totally
sir,
bow
it
down, my
was a
lord. There
3
has
months
been-
time which was given.
Yes, my lords. My lords had been, my lord, pleased to grant 3 months time, my lord. We have
No,
utilized it to the
that
fullest.
was the original order. But still, when you came and take a very sentimental or religious plea that because of the Rath Yatra, which
Look.
we also know is a very pious and a very important festive or festival of the state, we simply say that yes, all your officers are engaged there. We can appreciate it. Do it.
My lords.
But that does not mean that we have given you a complete.
No, my lords. No, my lords. But, my lords, we are also informed this honorable court, my lords, may see the first paragraph that 1430.
Which we
My lord.
noticed in course of the hearing of the instant content application, that despite a timeline having fixed for completion of the exercise in the order dated
21/9/2023.
21/9/2023, no substantial progress could be seen in the instant matter.
My lords.
Every time when the contempt application is listed, a plea on one pretext or another is taken, showing the progress having made in securing the compliance of the said order. Yet the adherence to such compliance appears to be a far cry. Today, when the matter is listed after 20th June 2025, the instruction is sought to be relied upon that the approach is made to the warden, chief wildlife warden, in terms of the provisions contained under Wildlife Within Bracket Protection Act 1972. On 5th January 2026, there appears to be complacency on the part of the alleged contemners in activating the entire system, ensuring the due implementation of the said order. Since the contempt proceeding is quasi-judicial in nature, as it is quasi-criminal in nature, we therefore direct the alleged contemners to file affidavit justifying their stand as perceived in course of the instant contempt proceedings. Such affidavit shall be filed within 3 weeks from date. List the matter after 3 weeks.
My lord, in the meantime, the name of the contender, I may be permitted to, my lord, correct, my lord.
Why?
Because in
Again,
the,
you are giving them.
my lord,
It's a Pune collector, Puri is there, whoever is there.
obliged.